Joining us today is one of the prominent employment lawyer in Malaysia, Ms. Vyen, partners from Raja, Darryl and Low. Ms. Vyen's core practice area is dispute resolution with a focus on employment and IR, issues pertaining to occupational health and safety as well as employment immigration are also within her practice area. In the course of her work, she has advised various clients on the management and handling employment and IR issues. Apart from providing advisory services, Vyen regularly represents a client in claims and appeals before the courts. Her performance as litigator has been recognized by the legal publication, which is Benchmark Litigation, and named her as a future star in its 2019 and 2020 edition. Okay, before we get started, if you have any questions during the presentation, please type them into the chat box at any time. If you rather ask in person, you can unmute yourself by end of the session and the speaker will answer your questions accordingly. Now, without further ado, please welcome Ms. Vyen.
Hi, good afternoon, everyone. The topic that we will be addressing today is the issue of probationers, how we handle and manage this specific group of employees in respect of that during their probation period, leading up to a possible extension and also a non-confirmation if the circumstances warrant. As part of this 1 hour session, I will share with you the law regarding the probationers, in terms of the probationers' rights as well as the employer's rights. And then moving on, we look at how to handle specific groups of probationers during probation period, best practices involved, and whether or not there are differences when we handle experienced probationers as well as probationers that are in comparison with probationers who are young employees, new fresh graduates, whether there has to be a different approach in managing them. And at the end of the session, we will then look at the common pitfalls, what to avoid and what to avoid and what not to do in terms of handling a probationer during a probation period. So I prepared a series of slides to guide us through this session. I will now share my screen with you. So when we talk about probationer, we often wonder whether there is actually a statutory definition for it. The answer is no. There is no definition of a probationer in a statute. It is not defined in the Employment Act. It is not defined in the Industrial Relations Act, which are the two main acts as far as the issue of employment law and labor laws in Malaysia are concerned. But when we talk about probationer, whether in colloquial terms or in terms of common law, we are referring to a new employee who is going through a trial period. Yeah, this is a period which is a useful mechanism to assess the person's suitability and fitness for the role. And at times, the probationers, and there are times as well where we use probation period to address and to assess an existing employee's suitability to a newly promoted position. This is uncommon. What we commonly see in Malaysia is probation period associated with the hire of new employees, whereby we assess an employee's suitability for permanent employment in the company. As far as the rights of a probationer are concerned, it is often a misconception that probationers do not have any legal rights. That is not quite accurate because probationers have similar rights as to confirmed employees. And the termination of probationers during the probation period on grounds of misconduct, midway through, or when a decision is made not to confirm them at the end of the probation period because this person is really not cutting it, it must be with just cause and excuse, which is the test under Malaysian employment laws when we end someone's employment. So this issue was actually canvassed and and addressed by the Court of Appeal in the case of Kalia Abbas and Pesaka Capital Corporation Sendirian Berhad. One of the arguments that was made in that particular case was this lady was an administrator who was hired by Pesaka Capital Corporation, and she was placed on a 3-month probation period. At the end of the probation period, a decision was made not to confirm her in employment because of the fact that her performance was not meeting expectations of the employer. So she filed a claim for unfair dismissal before the industrial court, and at the industrial court, the key argument that was taken up was that she is a probationer. There was no right for her to file a claim for unfair dismissal because she does not fall under the definition of a workman in the Industrial Relations Act. Let's bear in mind, when we look at the definition of workman under the Industrial Relations Act, there is really no distinction as to whether a workman is a permanent employee or permanent confirmed employee, and whether probationers fall under that definition. This issue has been addressed by the Court of Appeal, where it was held that probationers do come under the definition of workmen under the Industrial Relations Act, and they have a right to file a claim for unfair dismissal before the industrial court. So for that reason, when we approach issues of non-confirmation and termination of employees during the probation period, it must be with just cause and excuse. And if an employee fails to justify reasons for the termination or non-confirmation, there is a risk and exposure that the employer will be found guilty of unfair dismissal. As far as the probation period is concerned, I'm often asked whether or not there is a legal requirement to do so in Malaysia. The answer is no. There is no legal requirement to impose a probationary period in Malaysia, but to my mind, it is something that is highly recommended because it can be used as a mechanism by employers to assess the suitability of the person that was newly hired and to ensure that only suitable candidates are hired for the organization. In terms of the duration of the probation period, it really depends. It is at the discretion of the employer. And what we typically see in Malaysia is a period of between 3 to 6 months. And how we determine what is a suitable duration for probation would depend on the nature of the role and the difficulty of the job, the experience of the employees, and how long, most importantly, how long do employers feel that they need for them to gauge and assess the employee's suitability for the role in question. By and large, it has to be a fair approach across the board, whereby the same probation period has to be imposed for individuals and employees of the same category. Fairness in terms of industrial and employment law and practice in Malaysia often has to be the key. You can't be having a situation where there are 2 employees who have the same position but are subject to different probation periods. That would be a problem and an issue when a non-confirmation is challenged in court, because the question of whether or not the non-confirmation was fairly done and whether it was bona fide would then arise. One of the key things which we need to look at when we determine probation period is the contractual terms. It's very commonly seen in an employment contract where there is a specific provision and section addressing the issue of probation period. These are a couple of things which employers should bear in mind when they draft this particular clause. Firstly, most importantly, the duration of the probation period, how long. a notice of termination. As a general rule, the termination of probationers would be based on the notice period set out in the employment contract. A common notice period in Malaysia is something that ranges from between 24 hours to up to maybe 1 week, 7 days. Yeah, this is the typical range we should commonly see in Malaysia. And in terms of extension, it would really depend on the policy of the company, whether your handbook or your internal hiring policies stipulates an automatic right of extension when someone's performance does not meet the mark. Yeah. If there is an automatic right of extension, for instance, 1 month, that would have to be set out in the contract. If otherwise, it could be something as general as leaving it up to the discretion of the company. And in terms of confirmation of employment, it is often advisable to make it clear to the employee that confirmation of employment at the end of any successful probation period or any extended probation period will be communicated to them in writing. This is really a mechanism to protect the interests of the company so that it is made clear to the employee that there is no automatic right of confirmation, and it is made clear to them, and there's no assumption that the moment, for instance, the 3 months probation period ends, then they are automatically converted to the status of a permanent employee. On this score, I just want to share with you that as far as case laws are concerned, it is quite clear that the general rule is there is no confirmation until and unless it is communicated to the employee expressly. However, there are, as it always is with general rule, there are often exceptions, and there are often case-specific examples whereby the court has actually considered that an employee is automatically confirmed because of certain conduct of the employer. We will discuss this in detail later on in the next section of this webinar. So in terms of how to manage a probation period, it is very important to set expectations from day one. We will need to inform the employee of the job description, what their role is. Make it clear to the employee what is expected of them. Yeah. And set clear targets and set clear KPIs. It is unfair to the employee if targets and KPIs and even new job scopes are parachuted on them midway through the probation period. If this happens, and you would face problems if the employee does not meet expectations, does not perform as per your requirements because of this additional role or additional targets which is being imposed on them. There is a possibility and risk that the court may find that the non-confirmation because of the poor performance that is related to an additional task, additional targets that is imposed on an employee to be unfair. And there is a liability for unfair dismissal as a result. Apart from KPI and job descriptions, the other issue which is important is to make sure that the employees are aware of workplace practice and policies. This is specific for issues to address issues of breaches of SOPs and misconduct. For example, there may be certain prohibitions in place as far as a specific company is concerned, and there may be specific SOPs in terms of, for instance, approval processes, like procurement processes. There may be multi-tiered process involved in approving claims from employees. This has to be made known to the employees from day one. If this is not made clear to them, you would have a problem because you can't find fault against an employee for things which was not made clear to them and for things which they were not trained in the first place. So bear in mind, employee awareness of workplace policies and practices are also important. And the next thing to consider and to bear in mind is also the issue of open communication and record keeping. There has to be constant check-ins with employees to make sure that they are aware of how they are doing, whether they are performing up to expectations or whether they are falling short. If at all, shortcomings must be made known to them. Because most issues related to probationers are often performance related, it is very important to keep a clear paper trail of the communications that have been made between the supervisor and the employee, whereby it is informed to him that his shortcomings, he's not making the mark, he's not meeting expectations, to rebut the possible argument that he didn't know. It's a very common position taken by employees that he didn't know. He thought everything was hunky-dory, and pop comes a non-confirmation which he contends had taken him by surprise. So with good record keeping, with a good paper trail, we would be able to rebut this contention that he did not know what was happening. A structured evaluation process is also important as part of this ongoing communication with the probationer. For instance, if there is a 3-month probation period, it would be helpful to perhaps have, an initial 2-week check-ins and then gradually progressing to maybe monthly check-ins to see how the employee is progressing. Yep. Instead of periodical check-ins here and there without a proper structure. Lack of documentation may at times be a stumbling block when we defend cases of non-confirmation. Lastly, it is also important to monitor the end date of probation. By and large, I do not see this to be a common issue, but from my experience, it's quite important to monitor probation end date because we do not want a situation whereby an employee contends that the company kept quiet, although his probation period ended 1 month ago or 2 months ago. So he then assumes that he was confirmed because no action was taken by the company, no indication that his probation period is extended. So therefore, he assumed that his employment is converted to a confirmed employee. So we want to avoid all these possible issues. And because of this, it is quite important to monitor the probation end date. Consider at that point whether there is a need to extend the probation. If yes, for how long? Or if not, the employee has to be informed as soon as possible, ideally before the probation end date has lapsed. Because then it is clear that the employee is not confirmed and his employment ceases almost immediately. As far as the rights of the employer is concerned, we go back to the fundamental objective of a probation period. Fundamentally, the probation period is a chance for the employer to assess whether or not the person that was hired is suitable for the role. The general principle is an employee has no lien to the post he's hired for. He has no right to the post. And during the probation period, he is on trial to assess his fitness and suitability for the position. It is for the employee to meet the employer's expectations and not the other way around. So the employer has a right to determine, whether or not this person meets the requirements. Typical things which are assessed would be character, conduct, behavior, temperament, whether that person's temperament, for instance, if you're hiring him as a head of department, whether that person has the suitable temperament to take up a leadership role, whether he's someone who would be who is suitable and who's able to lead the team whom he's being hired to lead. Yeah. And whether he has suitable experience and whether the qualifications which that person claims to have is actually true. Yeah. So if an employer feels that the employee's character, conduct, behavior, temperament is not suitable for the organization, and it's not and there's no intention to confirm that person as an employee, as a permanent employee, the employer has a right to not confirm the employee at the end of the probation period. In terms of how to assess the probationer, like what I've mentioned earlier, you would have to assess whether not only work performance, also other subjective criteria. So there are two criteria: objective criteria, which is the work performance, subjective issues, which in terms of conduct, behavior, attitude, leadership skills, and whether or not this person is a team player. You know, these are things which an employer would need to consider when determining whether a person is suitable for confirmation. So this test is actually set out by the industrial court in the case of Indra Devi, where the industrial court held that the test to determine a probationer, whether the person could be confirmed, is as follows. The real test should therefore be whether the probationer possessed the right skill, competence, temperament, attitude, and suitability, which will entitle him to transcend from being an employee on probation to that of a confirmed permanent employee. So in terms of common problems which we often see as far as a probationer is concerned, these are often performance, in a way, performance related. The main issue which employers always face is a guy who does not measure up, who cannot perform the role he's hired for, job performance. Behavioral issues, where that person does not fit into the organization's values, conduct, and approach of doing things. Somehow it doesn't gel. Tardiness. There are times where the probationer does not come to work on time, does not have very, very poor timekeeping. These are common problems that we often see when we address issues of probationers. So in terms of senior and junior employees, there is a difference as to how these employees should be treated. If an employee is a young probationer, a fresh graduate with maybe 0 to very, very little years of experience, so a more structured guidance system and probation system has to be put in place to support this young probationer to enable him to perform during the probation period. So a more structured system in terms of guidance, the supervisor would have to provide support and counseling. You would have to monitor a young probationer more closely as compared to a senior experienced employee. Yeah, constant monitoring, constant guidance, more support would be needed when we are assessing a young probationer's suitability for performance, particularly for those who are seen to be struggling from the outset. Now, in terms of a senior and experienced employee, there is a difference on how this person is to be handled, because for someone who is relatively experienced in the particular job or in the particular field, or where someone is hired in a more senior management role, this person is expected to take ownership of the role. He is expected to be aware of what is expected of him, what he should do. And the courts have held that there is no need for a formal PIP process to be initiated for these senior employees. He does not need to be handheld, and he does not need to be handheld with close monitoring as opposed to a young probationer. So there are two case examples which I have picked out to highlight this point. So the first case is Chiu Pongo and Tujuan Ehsan. This involves a lady who was hired as a finance manager. So she was put on probation period for an initial 6 months and then a further extended probation period for 6 months. So she was at the end of the extended probation period, she was not confirmed on grounds of poor performance. Of course, she took the position that, hey, look, I did not know. I was not told that I was not meeting expectations. I was not told that there were problems. I did not know the company was not happy. Yeah. So because of this, your decision, company, to not confirm me at the end of the probation period is unfair. The court said no. The court said, by all means, the dismissal was fair because she had 29 years working experience in accounts and finance. Yeah. And this includes 10 years of working experience as a finance manager. And during the course of trial, if you can see from the award, there was evidence tendered by the company showing email exchanges between her and supervisor, whereby the supervisor had highlighted to her issues regarding her performance. There were follow-ups from the supervisor as to why this was not done, why is there a problem here, and constant communication. It is contrary to what she was alleging. It is not a situation where the employer kept mum, and then at the end of the extended probation period, comes and tells her that, hey, look, we are not happy, we are not confirming you. So on this score, the court says that there's no need to closely monitor her because she clearly knew what the expectations were. She's not a young employee, and therefore the non-confirmation is with just cause and excuse. Similarly, in the case of Ahmad Muhammad Khairuddin and Global Knowledge Network, this gentleman is a trainer. Yeah, he is a certified Cisco systems instructor. And prior to the commencement of his employment with Global Knowledge Network, he was hired by Global Knowledge Network on a freelance basis to train their technicians. So after 5 years, they were quite happy with him. They decided to employ him on a full-time basis as a technical experience, knowing very well that he had 18 years experience in the field. However, after he was onboarded as an employee, during his probation period, he refused to take on additional tasks to provide additional training in a certain new system. Yeah, he did not even prepare, and he did not even make any attempt to learn up the new system to deliver the courses which he was hired to do. So the company wasn't happy and decided not to confirm him at the end of his probation period. As similar to the case which I discussed earlier, the employee then came and argued that no, the decision not to confirm me was not fair. And he also took up the argument that he was not told about it. There were no show cause letters issued. There were no performance appraisals made. So therefore, he clearly did not know that his performance was not up to par. The court disagreed with him. The court took the position that, look, this gentleman is not a young employee. Different standards have to be applied. This is a gentleman with 18 years experience who was hired on a freelance basis by this employer in question for 5 years. So surely he knew what the expectations were. And evidence was adduced to the courts during trial that in terms of the new system which was required to teach the to counsel the employee, to teach the employees, to teach the technicians, it is not something which is beyond him. He had the skills and expertise to pick up the new system, to pick up knowledge about the new system, and then to provide the training courses which he was hired for. So in gist, the industrial court found that the non-confirmation of his employment was with just cause and excuse because he cannot, by virtue of his 18 years of experience in that field, contend that he did not know what was expected of him. He did not know what the job entails. So in short, to summarize this issue, two things. There are different ways to treat a young probationer and a senior experienced employee. In terms of a senior experienced employee, the general position is that they are expected to know what the role entails, and they are not required to be constantly handheld because they should be aware of what his roles and responsibilities are. In terms of a young probationer, a bit more handholding is required. A formal guidance process and counseling process would be required to put in place before a decision is made not to confirm the young probationer. So this summarize, general good practice in terms of handling a poor performing probationer is: one, make it known to the probationer about his performance issues and shortcomings. Secondly, chance has to be given to the probationer to improve. It can't be a situation where the employee is only told maybe at the end of the second month or maybe 2 weeks before the probation period ends that he's not performing. Then you have a problem because there would not be sufficient opportunity to allow the probationer to improve. You would then be faced with this hurdle of justifying and proving to the court that the 2 weeks is a sufficient chance for him to improve. So when the employee is informed of his shortcomings, it must also be communicated to him what are the specific issues and what is the specific goals and tasks to be achieved, time frame to be met, and areas for improvement. Guidance and advice have to be provided throughout. And if at the end of the probation period, the person does not improve or does not meet expectations, you will need to consider whether there is a need to extend the probation period. When we reach this juncture, unless there is a contractual requirement on the employer to extend the probation period, as a general rule, whether or not to extend it is really on a case-by-case basis at the discretion of the employer. Common question to ask would be, do we really see a real possibility of the employee improving if his or her probation period is extended? If it is not, if there's no possibility of that person improving, perhaps non-confirmation of his employment without even the need to extend the probationary period is something that we should be looking at as a realistic approach. So when considering the extension of probation period, like what I've mentioned earlier, look into the terms of the employment contract and handbook to determine whether there is a contractual obligation to extend. Okay, if no, then it falls back to the discretion, whether there is a justification for extending it, whether this person will improve or otherwise. Is there a realistic chance of this person turning around, meeting expectations, and becoming a star employee. Duration. In terms of extension, how long do you foresee you would need to further monitor the progress and performance? And how long would be a realistic period to be given to the employee for him to try to improve? And what would be the plan moving forward? Do we put in place a formal performance improvement plan or not? So more often than not, formal performance improvement plans are good, but whether or not to initiate a PIP for a probationer, it really depends, and it is something that you will need to consider on a case-by-case basis. But what is important, whether or not there is a PIP, would be constant monitoring, constant awareness of issues and shortcomings, and also opportunity given to the employee to improve. Now, so in terms of communicating the extension of probation period to the employee, it is very important for these things to be set out in a letter to the employee, communicating a few key points: reasons for extension, the issues, a summary of the issues that were communicated to the employee throughout the probation period, which requires his attention, duration of extension, and the consequences of not improving and not meeting expectations, which would naturally be non-confirmation of employment. It's ideal that this letter be issued to the employee, at the point where his probation period ends. So in terms of the end of probation period, like what I've mentioned earlier, when does it end? That is, notwithstanding the clause in the employment contract, case laws have said that there is no automatic confirmation period after, for instance, a 3-month probation period has ended. This issue was decided by the federal court in the case of Casey Matthews and Kumpulan Gatri. So what was held in that case by the federal court is, so long as an employee is not told that he's confirmed, he would then continue on probation unless informed otherwise. However, the caveat is, provided that the employee is not treated as a confirmed permanent employee. If he's given benefits and rights similar to that of a confirmed employee, that is when the problem would arise. For instance, if he's given an increment, which is typically given to employees who have completed their probation period, or if he's given annual leave entitlement similar to what confirmed employees are enjoying, or he's enjoying like medical benefits, claims and allowances which are only given to confirmed employees, that would be an issue, because by notwithstanding the fact that there is no written confirmation issued to the person, the fact that the employer has treated and given him the benefits and treatment as per a confirmed employee, it will therefore be implied that he is in fact a confirmed employee. So you have to be very conscious when dealing with an individual who has approached the end of probation period. Firstly, if that person is not confirmed, inform him. And if there is an extension of probation period, inform that person, and do not award this employee any benefits or entitlements which are similar to a confirmed employee too. Otherwise, you elevate his status to a confirmed employee. Yep. So like what I shared earlier, in terms of termination and non-confirmation, it must be bona fide, and the notice period that is applicable would be the notice period as per the employment contract. And in cases of, and some of the reasons whereby the court has held that these are actual bona fide reasons for non-confirmation would be instances where an employee's conduct, behavior, and attitude is really not suitable for the role that he's employed for. This was the decision in VK Technology and Ang Institute, yeah, where the employer has decided not to confirm the employee because his conduct, behavior, and attitude is not suitable for the role. Poor performance. Shamsuddin Mat Amin and Austro Enterprises. The employee was not competent. Performance was not up to mark. And therefore, the court held that poor performance is a bona fide reason for non-confirmation of employment. As far as the common pitfalls are concerned, these are common issues which we typically see in cases which have been litigated in court. There are no regular check-ins. So employers kept quiet. Yep. Everyone goes around minding their own business during the 3-month probation period. Employee is not made aware that the boss is not happy, the supervisor is not happy. Yeah. So the employee is not made aware. If that is the situation, we could not turn around and say the employee is not meeting expectations because he never knew about it. Second issue, which is quite common, is unclear expectations. No clear communication as to what is expected of him, especially when KPIs are involved. If KPIs are to be met and achieved, but it's not made known to the employee, how can we then expect an employee to know what the benchmark for assessment is? If the benchmark for assessment is not made known to him, the employee cannot be penalized for not meeting expectations. Yeah. Assessment on quality of work is also important. It has to be done periodically throughout the probation period, because if this is not done, it will be a case where we realize too late, where 3 months down the road, then comes the point where we have to decide whether to confirm an employee or not. It is at that point, you then look at the quality of work, the assessment, and whether or not performance were met and all. And when you found it will be too late at that point to then turn around and say there are performance issues. You would have problems even justifying the need to extend the probation period when things seem hunky-dory. What more justification not to confirm an employee in employment? So with those common pitfalls in mind, there is a possible risk of unfair dismissal if the performance and monitoring of an employee during probation period is not properly done. In addition to that, like what I've mentioned earlier, I also wish to stress that there is a need to also constantly ensure that the record keeping is good and there is a paper trail of communication between the supervisor and the employee that his performance is not making the mark. A common question which I get asked is whether or not there's a need to issue formal warning letters, whether or not there is a need to issue show cause letters. The answer is no. It is good that it is always good to have a formal letter from the company informing the person of the shortcomings, but there's no hard and fast rule. Communication could also happen in the form of day-to-day work, in the form of day-to-day emails, which are exchanged between the employee and the supervisor. That is sufficient proof to show that the employee was made aware of the performance issues. So if a claim is filed for unfair dismissal by a probationer, if he succeeds, the maximum possible exposure to an employer would be back wages up to a maximum of 12 months of last drawn salary. As far as reinstatement is concerned, that is a common remedy. That is the remedy that will be ordered by industrial courts for permanent employees, but it is not applicable for probationers because, like what I've mentioned earlier, they do not have any lien to the position. So there is no right to reinstatement and no right to compensation in lieu of reinstatement. Exposure, if any, is back wages of up to a maximum of 12 months of last drawn salary. So this brings us to the end of our session. And just to round up, what we have discussed earlier, the probation period, there is no legal requirement for a probation period. It is good to have, and in fact, it is something which I encourage to enable the employer to assess an employee's suitability for the role. As far as termination is concerned or non-confirmation is concerned, the burden is on the employer to show that there is just cause and excuse. Therefore, it's very important to manage the probation period carefully, monitor the end of probation period, make sure your clause in the employment contract on probation period is clearly drafted to set out the parameters, of the notice period, the duration of probation, and whether or not the extension is automatic, and to also more importantly, inform the employee that confirmation is not automatic. It will be made known to them in writing. In terms of young probationers and experienced probationers, there is a difference in how they are treated. No requirement to babysit and monitor closely as far as an experienced probationer is concerned. As far as a young probationer is concerned, there is a need to give him a bit more guidance and support to ensure that he is able to meet expectations. As far as the common pitfalls, do not leave things to the very last minute. There has to be constant communication, constant check-ins, make sure that expectations of the role, targets, if any, are clearly set out, benchmarks are clearly informed to the employee, and as far as the employer is concerned, make sure that there is a good paper trail, good record, and evidence of the person's shortcomings. So with a good paper trail, you would definitely be in a good position to defend a claim for unfair dismissal in the industrial court. Because without the paper trail, it would be your oral evidence against the employee's oral evidence. So with some corroborative evidence, contemporaneous documents, you are able to show that whatever you say is supported by documents which are contemporaneous, which were exchanged between the parties, which clearly show that the person is not meeting expectations. So with this, it brings us to the end of my session. I hope that it is helpful to all of you. And I now open this to the floor for question and answers.
Hi, if you have any question, you can ask right now. You can unmute yourself and ask question if any.
I think Izul has a question.
Mr. Izul, do you have
Hello.
Yes.
Hi.
Hello. Hi. I'm Izul. Can you hear me?
Yes, I can.
Okay. Yes. I have one question. Okay. So normally, prior to the confirmation, an assessment will be made by the staff with the superior lah. Okay. So we have some cases like during the assessment being made, the staff was told that he or she did not achieve the target. So means the company will terminate her. Okay, so what happened is the manager giving the staff two options. It's either you resign or being terminated. Okay, so the staff decided to resign lah. But later on, she filed a case for unfair dismissal. So how are we going to go about for these cases? Meaning that the okay, please proceed.
Yeah, sorry, just complete a question. Sorry.
Okay, so considering that considering that there is a mutual agreement between the staff and the manager, but at the end of the day, the staff itself claim that it's an unfair dismissal.
Yeah. Thanks
Okay,
for the
that's my
question.
question.
Yeah, I think what the issue that you are faced with is not really an issue of non-confirmation, but in reality, a case where an employee is alleging that he is forced to resign. Yeah. So in this scenario, what we need to, in order to defend the claim, we would really need to show that the resignation was voluntarily done, and it was not done under coercion or by the company. So we would need to look at the surrounding circumstances and the specific facts of the case to see whether it can be established that the resignation was brought about by the employee and it came from the employee voluntarily without any coercion from the employee. So the employee would likely contend that I was faced with the threat of termination and I would have no choice but to resign. Yeah. So in this scenario, the burden would be on the company to prove that, hey, look, no, it is all done voluntarily. So you have to go back to what was exchanged between the company and the employee to show voluntariness on the part of the employee. Yeah. I hope that addresses your query, Lisa.
Okay, thank you for the answer. Really appreciate it.
I believe there's another question.
Hi.
Okay, go on.
Hi, Miss Lee.
Hi.
Hi, I'm Ain.
Hi,
I would like to
Ain.
ask, is there any limit for the extension of probation?
Legally, there's no limit lah. But if you were to ask me, I would not advise continuous extension of probation because, to my mind, if someone is not making it, there's really no point from a practical point of view to continuously extend the probation. Yeah, because continuous extension would also mean that you're accepting the poor performance. You would then have a problem defending your position later. So to my mind, I would not advise an extension of more than even once.
Okay.
Yeah.
All right. Thank you.
Okay.
Any more questions?
Oh, okay. I think I see a question from Ruwan. So the question relates to the issue of PIP and whether or not we should place probationers into PIP at the beginning of the term. To answer the question, Ruwan, I would not suggest, I would not, how do I put it? In order to embark on a PIP, we would need to show that this guy was not meeting expectations. So for the sake of argument, if that person is on a 3-month probation period, it would be very odd to already put an employee on a PIP after 1 month. Yeah. So to me, I would advise, instead of placing a formal PIP, maybe impose a process where there is a structured monitoring process, not a formal PIP, but a process where there is structured guidance, structured monitoring, and structured performance feedback sessions with the employee. And then maybe do progress checks every month. Yep. Instead of a PIP from the very start, because the whole purpose of probation period is for the employee to try to meet up the employer's expectations. So PIP so early on would be a bit presumptuous, and it would actually mean that you have already formed a conclusion that that person is not making it. So perhaps if you really want to consider a PIP may be something which the company wants to think of when an extension is being considered. For instance, if an employee is not making the mark, but you see some chance that this person would improve if his probation period is extended. So for instance, what you could consider is at the end of the 3-month probation period, impose a PIP on that person during the extended probation period to monitor the performance, and to hopefully with that monitoring and guidance, that person would improve and meet expectations, and then will be confirmed in employment. I think Izo has another question.
Hello. Hi. Okay, I have one more question. For example, the staff already tender her resignation. So, do the company required to proceed with the assessment of confirmation? For example, the staff is in her last week of the probation, and then she decided to tender. Do we need to continue with the assessment or just proceed with the resignation?
To my mind, if the employee has already resigned, I don't see why we still need to assess. Yeah.
Okay.
So maybe what we can do is internally we can do something to close out in terms of the assessment internally as part of the personal file. But as far as the resignation is concerned, just deal with it as it comes, as a resignation process.
Okay, the reason that I'm asking this question is because it's related to the previous cases whereby that the staff was told that she did not achieve her target. So the assessment was not made because she already tendered her resignation. Right. So now she claimed for unfair dismissal. So now the assessment is nowhere to be found, not signed by the staff itself, the former staff itself. So how are we meaning to say that that is one of the document that is very good for the company to tender to the court. But we don't have the document.
Yeah, sorry, I think I misunderstood you. I thought you meant the assessment at the end of the probation period, where at the end of the 3 months you then assess. If you're talking about periodical assessments, although that person has already tendered the resignation, well, to my mind, he's still your employee. It would be good to have those in place, especially if you see that this person is going to be problematic. Yeah.
Okay.
It's good to have.
Okay.
Yeah. Or if, especially in cases where you do not have a complete paper trail, no email correspondence to show that she's not making it. How when I mentioned earlier the issue about the importance of having these constant check-ins and constant communications, especially when there's this shortcoming there. Yeah. So then this assessment before the end may be something that you need to look at.
All right. Okay. Thank you for the advice and opinion.
So there's also a question from the floor from Arif that how do we classify someone as experienced or young probationer? Do we have the exact years of experience? To answer your question, no, there's no legal definition of what is experience and what's not. It really depends on case-by-case basis. And when we talk about experienced probationers, it would mean someone who has been working for a while, someone who has experience and knowledge for the specific role. For instance, if you hire a marketing manager, for instance, if that person has about 10 years experience, so of course this person would be considered as someone who's experienced and has to be treated differently from a young probationer. A young probationer would typically be someone who fresh graduate, 1 or 2 years job experience, that kind of thing. So it's quite, you need to assess when that candidate comes in, you would be able to tell whether that person is experienced or not. There's another question by Mohanan. Is there a need to conduct a PIP before we terminate an employee? Before we not confirm an employee at the end of the probation period? The answer is no, there is no strict legal requirement to conduct a PIP, but what we would need to do is you need to ensure that the 4 things which I've mentioned earlier, that the employee is made aware of the performance issues. It cannot be something that's done last minute. It must be something that has been continuously done. And then he is given chance to improve. Guidance and support is given, but yet that person does not improve. So long as you are able to establish this, then yes, there may be grounds not to confirm the employee at the end of the probation period. I hope that answers the question, Mohanan. Okay, this is a very interesting question from Sharia. The question is, what happens if an employee does not perform or is not confirmed due to ill health? It would really depend, Sharia. It's quite difficult to answer whether or not it's fair or unfair. Of course, we would also need to balance this issue along with the need for the employer to run a business. We can't be expected to put up with an employee who is unable to come to work, unable to attend work and perform his duties. But at the same time, what you should weigh, what an employer may want to consider is, okay, if the employee is not present to work due to ill health, maybe, she has recovered. So maybe we can extend the probation period for another month or so to gauge the employee's suitability. So these are things which you need to consider. And these are things which the court will look at in determining whether or not the decision not to confirm an employee due to poor performance associated with health reasons is unfair or not fair. Yeah. So these are things which the court will balance. Employers need to run the business, interest to ensure that the business is run without interruptions, and that the employee meets expectations against the question of fairness, whether sufficient chance is given to the employee to prove, and whether we should extend the probation period for a bit to see whether the employee is suitable for the role.
Any more questions from the floor?
Hello, Izul here again. One more question, last one. Hello?
Yeah. Go ahead.
Okay, so as mentioned before, we need to differentiate the probationer with a permanent employee by not giving the probationer to enjoy the same benefit, right? Okay, so what if the company giving the probationer partial to enjoy the partial benefit partially, meaning maybe the probationer can enjoy annual leave and sick leave, but not receiving any increment, like say for example medical costs, right? Macam tu partially lah. What I mean is the probationer enjoy partially. So is that mean the probationer considered as a permanent?
No, so long as it is very clearly stated that For probationers, you would get, for instance, how do I get it? So, for instance, for probationers, in terms of medical allowance, for instance, probationers, you only get 100 ringgit a month, 100 ringgit throughout. And only after you are confirmed, it would then be increased to maybe 500 ringgit a year, that kind of thing. And annual leave entitlement, there are certain situations where probationers would get leave on an as earned basis, whereas permanent employees, confirmed employees, can take leave upfront. You know, that kind of scenario. And in the two cases,
Yes.
and in the two case examples, which I cited earlier, it was a case where they did not have any annual leave entitlement during the probation period. And then for some reason, the employee was, after the expiry of the probation, the so-called expiry of the probation period, he and she were then given annual leave entitlement, although there's no letter from the company confirming them in employment. So that was when the trouble started. So the court said, hey, look, she's given annual leave entitlement just as a permanent employee. So by virtue of the company's conduct, the company is actually viewing them as permanent employees, and they were not even probationers. Yeah. So you have to be very clear when you give this kind of different benefits and increments and all. Yeah.
Okay.
Hi, Ms.
Any
Tan.
question?
Yes.
Yes.
Yes, Denise here. I have a question on the probationer. Can we do a transfer to other department and impose another probation period duration, let's say for another 6 months?
You can, but you need to make it very clear to her. Are you
I see.
talking about a situation where someone is being transferred on
Towards ending the probation period and found that this person is not suitable holding the current role, and instead of extending the probation period or termination, we intend to transfer her or he to another department and start the new probation period again, just to assess the skill set.
That's something that can be considered. But what I would advise you to make it clear is you need to then get the probationer to clearly agree to this extended probation period and the transfer to a new role. Then once she's onboarded to the new role, make sure that the expectations of the role and then whatever benchmarks and targets that the person is supposed to meet is made clear to her. Then you start.
I see. Got it. Thank you.
Any more questions?
Apa tak boleh buat bagi saya rasa sebab saya terpilih dia kata sebab rasa position tu pindah ke department lain sekejap, betul hari tak habis ada cuti hari apa gabung hari tak habis boleh buat project.
Ms. Vyen, there's actually a question from Ms. Nur Iza. I've typed it in the chat box. Will you be able to see it?
Yes.
Okay.
Is there lots of issues? So in terms of this question, so there are two parts of it. One is failure to meet targets, and one is the reason is attributed to the pandemic. So in terms of targets and in terms of whether or not the employee should be faulted for failure to meet targets. So for the benefit of everyone, the question is, there are, by reason of this pandemic, and probationers who do sales jobs, there are some of them who would face difficulties meeting the targets because of the face-to-face meeting and then the work from home arrangements and things like that. So if this is the situation, and even though probation was extended, so is there justification not to confirm the employee at the end of the probation period on grounds of poor performance? So in order to answer this question, we would need to look at the targets that were initially set. The court would look at targets to determine the reasonableness. And in terms of attempts to achieve those targets, whether the targets were realistic and whether there is any evidence of the employee attempting to do whatever they have to do to meet those targets, or is it a case where the employee really did not do anything? The court will also look at whether the employer was realistic to maintain those targets despite the pandemic, or whether it's a situation where it is an unrealistic target which the employer should have scaled down given the scenario in hand. So it really depends on how this whole thing plays out. And at the end, and if the employee does not meet those targets, and if that is challenged in court, these are the things which the company will have to show. They have to show that the targets were realistic, there were alternative means available to the employees to meet those targets. We do not need to have face-to-face meetings. We could do virtual meetings. There should be steps taken. So perhaps as part of the counseling and support process during the probation period, perhaps it would be good and it would actually work for the company's defense to show that they have actually tried to facilitate and they have actually tried to assist the employees to meet the target by providing alternative means to the employee to try to achieve the targets, but despite that, they have not done so. So these are things which the court will consider in determining whether or not the decision is fair or not.
Hi, Ms. Lee, Eza here. I'm the one who's asking the question.
Yeah.
Okay, just additionally, okay, if let's say we're now taking into consideration the COVID-19 pandemic, now we are facing the unprecedented situation. Okay, what will be the trend in industrial court now? What are they looking at the how do I say, these things, this employer might be not able to achieve the target because of the COVID-19, the pandemic. So he's not able to meet people efficiently, effectively. So, so will the court consider this as a strong reasons that could be justify the whole non-confirmation, if in this case?
So, to my mind, it will really depend because I have not come across any specific cases that deals with the COVID-19 issue.
Okay.
So it really boils down to how well you can justify your decision. So that is why it is quite important, especially when it comes to performance and targets are concerned. The first question the court will ask is whether or not the target is realistic. Whether or not you can meet these targets in this day and age. If this is realistic and is something that can be met, whether the company has given enough support to the employee to try to meet those targets. Yeah. So, you know, when you're talking about performance, you have to give support and stuff like that. So whether or not support has been given, whether or not you have given them guidance to try to meet those targets, or is it a case where the employee was just working from home and nicely not really working from home, that kind of scenario, not taking initiative? Yeah.
Yep.
So these are all the things that the court will have to look at cumulatively, and you would need to show that you have done all you could, and therefore your decision not to confirm is justified.
Noted.
So it's very important because it's a very fluid situation.
Yeah.
I think as for employers who are dealing with employees in sales role, it may be helpful to, you know, look at your targets as and when the things change lah. You know, it's so fluid, can yeah.
Yep. All right. Thank you.
Okay. Thanks.
Okay, I believe there's no more questions. All right, on behalf of IR Law, thank you for joining us today. We appreciate if you can let us know your feedback by answering the poll questions in front of you right now. And a big thank you to Ms. Vyen for your valuable time Thank you again, Ms. Vyen.
No
Bye.
worries. Thanks, everyone. Bye.
Okay, we will have a quick session with Mr. Raja Vishnu, who is a principal IR consultant. For non-IR law member, this is your opportunity to ask any question to Mr. Vishnu and get to know more about IR law. I will pass this session to Mr. Vishnu.
Miss Lee, can you hear me? Thank you very much again for joining us today. We hope to see you again for our future webinars. Hello? Hello? I hope you all can hear me. Miss Lee, thank you very much once again on behalf of IR Law for attending, for presenting in our webinar session. We hope to see you again in our future sessions. Can you hear me?
Yes, you're welcome, Mr. Vishnu. Thanks for the invite, and I really had a very enjoyable session, sharing my views and thoughts with your team from IR Law as well as all the participants. Yeah. So just feel free to give me a shout if you need anything.
Great. We'll keep in touch.
Yep. Take care.
Okay. So Umi.
Yep, I can hear you.
Okay, great. So the I think the other participants who were going to stay behind, are they there?
Yes, I believe so. There's still 50 people in the floor. You can continue, Vishnu.
Okay. I'm Vishnu. So I believe some of y'all are still there. My name is Vishnu. I'm a consultant in IR Law. So today's topic was indeed very, very fascinating. And we learned a lot from Miss Lee. One other issue I'd like to point out is in terms of, I think one issue that we need to address is the fact that probationers per se is actually not actually mentioned in the IR Act, but it is mentioned in the schedule to the IR Act, meaning that in terms of liability, so you need to manage your probationers really well, because in terms of liability, if it goes to the IR court, the liability which the employers face for an unfair dismissal claim in relation to in the case where the employer dismisses the probationer, it is 12 months limit. It's a 12 months. Unlike permanent employees, it's 24 months, whereas for probationers, it's 12 months. Just to let you know. So there is a liability there. And also we in this discussion, I think many times, I think Ms. Lee has emphasized as well, on confirmation. I think many of you you have this idea of non-confirming staff. So do I need to do a PIP? I believe Ms. Lee has emphasized really well on this issue prior to non-confirmation of staff. Non-confirmation is a termination. So the only question of whether you need to do PIP before you non-confirm a staff, if the issue is a poor performance aspect of the probationer, then the probationer period itself is a form of PIP. In a sense, when you do assessment during the probationary period, you need to do performance analysis and assessment to gauge the performance of the staff. So I believe on that aspect, during the probationary period as well, that is a form of PIP as well. And we don't call it a performance improvement plan, but it's an assessment period of the probationer, whether the probationer can meet the expectation of the employer at that time. So when you do your assessment at that time, and you find during the probationary period itself, the staff is not able to perform, so towards the end of the probationary period, you can come to a decision whether you can continue the staff in employment on a permanent basis, or you can terminate on the grounds of poor performance. So non-confirmation is actually a termination of employment. Okay, so you do need a just cause and excuse for non-confirmation, similar to how you terminate probationer. It's the same thing. So I just wanted to say that because Ms. Lee has explained really well. So just to re-emphasize on that part, because we do get a lot of questions and queries on this aspect as well. So anybody else would like to address any issues, especially on probationers issue, especially those who are interested on our membership. Hello, Umi.
Yeah, continue. Vishnu, you there? Vishnu.
Okay, would anybody like to pose any further questions on our services and so on? Maybe you should unmute your.
And you can ask any question to Mr. Vishnu if you want.
Okay, basically, just to introduce ourselves, we are IR Law, and Miss Umi is our marketing manager. She is the one who manages on and also organizes our webinars and seminars and conferences and so on. Whereas I'm the consultant, so we provide consultant services on all industrial relations and employment related matters. We have an upcoming conference this July, but of course, due to the pandemic situation and so on, we are still going on with it for the moment, but subject to changes, probable changes in our government's directive in view of rising cases recently. So that is still subject to a final decision. Either we may go ahead with our conference this July, or we may postpone it to a later date, but we will definitely will be having it one way or another. So that is one aspect. Second aspect is we do provide services in terms of litigation when it goes, your cases are handled by our members, which go to the industrial court. We do provide legal support as well. That as well, we have a team of lawyers, associated lawyers who work with us in all our cases to industrial court. So that too we do. And we do provide digital resources in terms of case research as well, where members are given access to our digital library where they can access cases on all aspects of HR and industrial law cases, judgments which have been handed down by the industrial court. You'll be given access to view, to search, to download these cases as well. We have about 80,000 cases in our database. So that seems to be one of the more popular or more appreciated feature of our services as well. So any of you, if you have any questions, you could unmute yourselves and we could take it from there. But you need to unmute first.
Vishnu, there's a question.
Okay. Let's go ahead. Please shoot. Your miss.
Miss Sairzan Mak Saleh is asking, is it compulsory to conduct DI for those employee under probation period doing misconduct, or we just can terminate?
Okay.
His contract?
Where is he from? Which company? Which company, Umi?
Hold on, let me check. Is Sairzan?
Okay.
Plantation company.
Domestic inquiry. When we talk about domestic inquiry, what we are referring to is an actual domestic inquiry process with a panelist, with the prosecutor and the accused and the tender evidences. So it's a full-scale domestic inquiry. So your question is, do we have something like that for a probationer, someone a probationer? Okay, it depends on the kind of case. If the probationer is facing a major misconduct, you have an intention like theft, sexual harassment, So regardless whether that employee is probationer or permanent employee, you need. So the need for domestic inquiry comes from the nature or seriousness of the misconduct. So now we're talking about misconduct, no longer per performance, but meaning that the person, whether probation or permanent employee, has done something so serious. What we have in view, in mind, is for us to dispense with through a demotion or maybe even a termination. So these are serious forms of permission. So DI is very, very necessary if you want to terminate or if you want to demote an employee, because these are considered very, very serious forms of punishment in industrial law. But if you have in mind a simple warning, a final warning, for example, then those kind of punishment in mind, you don't need a full-scale DI. What you need to do is to fulfill due inquiry. What you need to do is just give a show cause and wait for his reply. Then you take it from there. So whether or not we hold a DI, whether we're talking about permanent employee or probationary employee, it depends on what kind of misconduct the employee has committed, whether serious, major misconduct or minor misconduct. So that's what we look at. We don't look at the fact that just because he's a probationer, we don't hold a full-scale DI. Because bearing in mind, as I mentioned earlier, under our Industrial Relations Act, under the schedule, the liability for probationers is 12 months. Meaning that if it goes to court and the employee loses the case, the liability is 12 months back wages, half of that of a permanent employee. A permanent employee is 24 months liability. The probation employee is 12 months. So there is still liability there. So it comes, this liability thing comes under the schedule to the Employment Act, to the Industrial Relations, sorry. You can find it in the schedule, second schedule to the Industrial Relations Act. So with that in mind, bearing that in mind, what we need to do is look at the nature of misconduct, what the employee has done, rather than whether he's a probationer or confirmed employee, because both sides, in both ways, you are liable in industrial court. Okay, I hope that answers your question. So if it's a simple issue that the employee has done, if he's a probationer or permanent employee, we just give a show cause. That fulfills the requirement of due inquiry. So show cause will be enough, and then we get his reply. Based on that, you can assess what kind of punishment you need to dispense with. Okay, thank you for your question, sir. I hope that answers your question. Any further questions or discussions we can have on our services, please go ahead. Please shoot. Okay, thank you to you too. Please free to type in or even unmute. We can have a conversation while we are unmute. So for those of you, perhaps we could arrange, we could have further conversation on this aspect or any other aspect. We could arrange an online meeting with yourselves. Please email us or can get in touch with Ms. Umi. We could have an online meeting and we can discuss not just on aspects of our membership, but also the problems you are facing right now in your industry. Bearing in mind, right now, because online meetings may be more emphasized from henceforth, because we are facing a sudden surge, as you're all aware, we are facing a sudden surge of pandemic cases right now. I believe the government will be setting up a meeting tomorrow, latest by tomorrow, to determine whether we're going to go on full-scale lockdown or not. So with that in mind, I think all companies, all industries concerned must be very aware that for the immediate future, at least, you're going to have to go online meetings for a moment. Face-to-face meetings are going to be very difficult for the time being, because we may go into full lockdown within the next few days because of the sudden surge in cases, which is quite serious today. In fact, I believe it's gone up to 6,008. Not to scare all of you, it's just that any future meetings we have, preferably we need to arrange it online. So with that, if any one of you would like to meet up, set up a specific date on an online meeting, please email us or you can get in touch with Miss Umi. I believe, okay, we can end the session, Miss Umi, since there are no questions.
Okay, if there's no more question, that's the end of today. Thank you very much, everyone.
Okay, take care. Thank you
Thank
for
you. Stay safe. Stay